Okay, so we should now have our aviation legal experts before us. They are just joining on the screen now. Very good morning. I'll ask you to both introduce yourself. Antonios, should we start with you?
Yes, good morning, everyone. Thank you for the invitation. My name is Tzanakopoulos, and I'm an associate professor of public international law at the University of Oxford. And I'm also the Secretary General of the International Law Association.
Antonios, very good morning to you, and good morning to Miles.
Thanks, Chair, and thanks everyone for the invitation. I'm Miles Jackson. I also teach international law at Oxford, and I'm a fellow of Jesus College.
Well, two professors from Oxford, which is always welcome. Thank you very much for being with us. I hope you managed to listen to the evidence from Michael O'Leary from the operator's perspective. We'll now focus on the legal ramifications. Before I hand over to Gavin Newlands, perhaps I could just open by asking, is there an argument that Belarus has breached international aviation law? Who would like to start?
I'm happy to go. Chair, the answer is yes. I think there's a strong argument, though, of course, as Michael O'Leary said, we're waiting for the report from ICAO. There's a strong argument that Belarus breached both the Chicago Convention and rights thereunder, as well as the Montreal Convention of 1971.
And can you give us a bit more detail as to sort of where those breaches may have occurred in terms of the various articles?
Of course. Maybe I can go back a step and
Please.
say something about what the Chicago Convention is trying to do. It's trying to balance something quite delicate, which is states' rights in respect of their own airspace, with an ambition to allow for civil aviation to go ahead. And it strikes that balance in a number of ways in the terms of the convention. So if we look to 3 bis of the convention, it allows states to require a plane to land in certain circumstances. So we see this balance being struck, and those circumstances are twofold. It allows a state to require landing if the civil aircraft is flying without authority. That doesn't seem to be the case here. Or if there are reasonable grounds to conclude that the aircraft is being used for any purpose inconsistent with the convention. And that also doesn't seem to be the case here. So on a straightforward application, given what we know of the facts, it looks to us like that's a breach of that provision of the Chicago Convention.
Okay.
Similarly, the Montreal Convention sets out a number of provisions that relate to the safety of civil aviation, and sets out a number of unlawful acts in relation to the safety of civil aircraft. Now I'll read to you one of the offences specified in that convention. Article 1 provides, any person commits an offence if he unlawfully or intentionally communicates information which he knows to be false, thereby endangering the safety of an aircraft in flight. So those two provisions of those two conventions seem to us to have been breached.
Okay, thank you very much, Miles. And Antonius, and again, it's a curious one because I'm sort of deliberately being cautious because there's a report that's still to be made and that deliberation. But actually, the EU and the UK have already actually put in place sanctions and punishments. So we've obviously sort of reached a view that there has been some form of breach. I just wondered if you had any sort of commentary from that perspective. I mean, is it absolutely clear that there has been that breach and therefore we're just really waiting for the inevitable, which is the report from ICAO?
And I think, as Miles said, it's reasonably clear that there has been a breach here based on the facts that are publicly available at the moment, precisely because we do have a situation where the aircraft was clearly not flying without permission in Belarusian airspace, and also was not being used for purposes contrary to the purposes of civil aviation in the convention. So I can't see any way in which you could argue that at least 3 bis has not been breached, and similarly with the Montreal Convention, we have an issue there as well. So it's pretty clear to me, as Miles said, that there is a breach, and then what usually happens in international law, which is a decentralized system, is states appreciate the legal position for themselves. So clearly the UK appreciates the legal position for itself. It can determine for itself that this breach has taken place. And it can react to that breach by putting in place measures, not punishment. You're not supposed to punish, but countermeasures, sort of measures that respond to the breach by a counter breach, basically telling the state, the other state, the responsible state, unless you accept that you have breached the law and make good on your breach by offering, as Michael O'Leary said, for example, assurances and guarantees of non-repetition. This is what the law of state responsibility would require. We will breach the law towards you, or we will impose measures against you until you do so. So these are measures meant to induce the compliance of the state rather than to punish it. And it's good that we keep that in mind. I'm not sure if that's sort of like helpful to you.
It was. It was, because it's a nuanced position, because there have been sanctions interposed, but we haven't actually had the determination by the official body, being ICAO. Let's go into a little more detail about the sort of legalities, and then we can then talk about the sanctions and not the punishment, to your point. I'm going to bring in my colleague Gavin Newlands, who's on mute, I think. Can we take him off? Sorry, Gavin, bear with us.
Hello, good morning.
You're coming across loud and clear.
Oh, excellent. What a relief thought to all of us. Good morning. In terms of going a bit deeper and perhaps in terms of the offences itself and whether or not the flight 4978 was an act of air piracy. And from what I understand, in terms of air piracy, generally it's somebody on board an aircraft who seizes or exercises control by means of threat, force or intimidation. But in this occasion, it would appear that intimidation or direct intimidation didn't exist on board the aircraft, but that there were fighter jets outside the aircraft. And we heard from Michael O'Leary already that on landing, when asked on camera whether or not they had landed there, of their own accord, they refused to do so. So is this an act of air piracy or not? And I'll go to Dr. Tzanakopoulos first.
No, I don't think it is an act of air piracy. It doesn't fall within the scope. It doesn't seem to fall, based on what we know, of course, right? So this is all subject to sort of new facts being brought to life. There is a lot of talk about state-sponsored hijacking and whatnot. We do have the 1970 Hague Convention on unlawful seizure of aircraft, which is commonly referred to as the hijacking convention. And as you stated, this requires some sort of control over the aircraft to be taken so that we have a seizure. Now, the way that we understand that control has to be pretty narrow in that convention. So it has to be through intimidation or threat or use of force over the pilots or in the cockpit or direct seizing of the aircraft. Otherwise, we would have no way to separate an interception from the actual seizure of the aircraft. Because if you consider, and of course, from Michael O'Leary's perspective, I understand that, if you are the pilot, you're being told by ATC you have to divert, and at the same time, you're being sort of shadowed by two MiGs, which is fighter aircraft. Obviously, it doesn't seem to you like you have too much choice in terms of what you do. But that still doesn't mean that the aircraft has actually been hijacked within the meaning of the Hague Convention. What it means is you are subject to a situation of being intercepted, and you have to follow the fighter jet and so on and so forth. But you haven't been hijacked in that sense. And if we don't draw that distinction, then any time that any state intercepts any other aircraft, we will have state-sponsored hijacking, which is clearly not a position that we want to be in, because clearly also the UK will intercept aircraft that enter unlawfully and so on and so forth. So I would be careful with that terminology in legal terms. I mean, I understand it in more colloquial terms and whatnot, but in legal terms, based on the facts that we have right now, I mean, there is this question as to whether there were KGB agents on board, whose KGB agents these were, and what they did on board. But unless it can be shown that they actually, A, are Belarusian agents, and B, they somehow seized control of the aircraft, either directly or through intimidation to the pilots in the cockpit and so on and so forth, then that would not fall within the Hague Convention on the unlawful seizure. So that's how I would put it.
Okay, Dr. Jackson.
Yeah, maybe just to add one point. As Antonio said, we need to wait for the factual report on some aspects of the applicability of the hijacking convention. And like Antonio, I understand the political or extra-legal force of the designation as hijacking or terrorism or piracy. But it doesn't need to be hijacking or piracy to be a very serious breach of international law, a very serious breach of a very well-functioning regime of civil aviation, of equal seriousness in many senses.
Okay, that's fair enough. And Dr. Jackson, if I come to you with this one, given the situation what Belarus have claimed, and you'll have seen what Belarus have claimed, in fact you've written about it, how difficult is it going to be to prove that Belarus knowingly committed false information, or communicated, false information about a safety threat, obviously a bomb, as they had said, from Switzerland, on board the flight? How difficult is it going to be to prove that?
I think we'd have to wait for the ICAO report, but if you're making that kind of assertion essentially as a justification for your conduct, you would need to put forward the information, the proof or the evidence to ICAO. They may have that evidence, but ICAO will have to make a factual finding about credibility, reliability, and whether that's actually borne out. So I think that Belarus will need to show that they were acting within the terms of this exception, and if not, it will be unlawful.
And Mr. O'Leary said that from the information that he has heard, that the email or the communication from Switzerland regarding a bomb was half an hour after the plane that they had been in contact, ATC had been in contact with the plane. Are you aware of that as well?
That is the story I've seen reported too, which would be quite a good indication of falsity. Okay,
fair enough. I shall move on. Do you think, and I'll come back to you yourself, Dr. Tzanakopoulos, does the international aviation community have the appropriate legal and enforcement tools to respond effectively to this situation?
Well, it depends on what you mean effectively. I think,
what do you mean by effectively?
Well, I think there are a number of ways to react to this, both within the context of ICAO and in a decentralized manner by states, and we've already seen these reactions taking place. So now you can take issue, as Mr. O'Leary did, with sort of the measures taken in response, but there's a wide variety of measures that are available in response to such incidents. And this is generally the way international law works. When there is a violation and there is a determination that a violation has taken place, the way that states react is by taking countermeasures, trying to put enough pressure, enough inducement on the responsible state to basically either seize the violation and offer assurances and guarantees of non-repetition and potentially offer reparation for the breach, but more importantly, to get that state to the negotiating table to figure a way out of the whole thing. So the tools are there, but of course, for them to be effective, you have to be smart about the tools that you use. So if you end up sort of in your reaction, in your sanctions, as they're sometimes called, or countermeasures, as they're legally called, you may end up hurting yourself more than you're hurting your target. And we have an indication of that, sort of like if your immediate reaction is, oh, we just banned Belavia and we just banned overflight and so on and so forth, you might be causing more trouble in the long term to civilian aviation than you're dealing with the case at hand.
So you tend to agree with Michael O'Leary's point on that matter?
I mean, I understand the problem of taking the immediate reaction being this for a short period of time, but it's clear that if you want to get Belarus to sort of come back in line, as it were, then perhaps other types of countermeasures, other types of sanctions in the instance would be more effective than just flat out banning them from all over the place. Also, this has sort of perverse effects on people trying to leave Belarus for all sorts of reasons.
Fair point. So sanctions such as, can you give an example of the sanctions that you could perhaps levy instead then?
There are all sorts of sanctions that you can do, anything from sort of more generalized trade sanctions to increasing particular targeted sanctions on the leadership of the state. You could take particular targeted sanctions, so individual sanctions against the local civil aviation authority, which after all was involved in the instance. So, for example, its head and people that were involved in the incident, including through travel bans, asset freezes, and so on and so forth. There are also possibilities of taking all sorts of measures that are very lawful, but unfriendly in that sense, and that also increases pressure of the state. So stopping voluntary aid, recalling ambassadors, or downsizing the diplomatic mission. All that stuff puts pressure in a more generalized manner, and sends a very clear signal that you have to going to come back into line, or at least sit on the negotiating table and find a way out of this. Otherwise, we can make this very painful to you. So that is the general idea.
Okay. And Dr. Jackson, have you got anything to add to that?
I would just add, maybe in a wider sense, there's political judgments to be made by the state in not imposing self-defeating measures in the first place, and second, in thinking about the negative effects of sanctions or bans on civilian populations who weren't involved. That's just a judgment that has to be made. And so an automatic ban on flights out of Belarus is likely to affect civilians, ordinary people, quite seriously. So that's all in the mix that should be considered by the state.
Okay, and last question from me as we're coming up to half past. In terms of this incident, has it highlighted any potential shortcomings in any of the agreements? Do you think anything needs to be done in terms of the Chicago Agreement 1978 or Montreal? Is there anything that you think would require updating to address this situation?
I think the exceptionality might highlight that it's been working quite well. Mr. O'Leary said something quite important, which is states have to be able to rely on messages from civil aviation authorities, from air traffic control. They have to be able to rely on it. They can't go behind that instruction. But this has garnered so much attention because it's exceptional. So I don't think so. We'll see what ICAO does and what happens thereafter.
Do you agree, Dr. Tzanakopoulos?
I mean, I tend to agree. I think Miles is absolutely right. The fact that this is so exceptional actually highlights how effective the regime has been. There are also methods for the resolution of disputes in most conventions, and in particular in the Chicago Convention, this can be used to great effect. It is actually being used by Qatar in the instance, and I'm sure you're familiar with that situation. This may end up before even the International Court of Justice in The Hague, so the UN principal judicial organ. So it is an effective regime. I don't think it's a question of amending it. It's rather a question of dealing decidedly with its violation in the instance.
Application enforcement rather than changing. Okay, listen, thanks so much to both of you. Back to you, Chair.
Gavin, thank you. I just wanted to see, Graham Morris, did you want to come in?
Yeah, I wonder if I might just ask our academics about. I think I understand the advice or your expert opinion in respect of what appropriate sanctions would be, and I know that you heard Michael O'Leary's evidence earlier and you seem to agree with him about the importance of maintaining the integrity, the freedom to overfly states, including Russia and Belarus and the Ukraine. But doesn't it seem, it's reprehensible what happened. I don't want to prejudge I'm not trying to defend that at all, but it seems that the victim in this is the airline Belavia. So is your in terms of the sanctions directed against them in particular, so is your academic opinion that the response of the international community should be not so much directed at the Belarus airline, but against individuals involved in that political decision? Is that the gist of what you're saying? You know, with asset seizures or other sanctions against individuals that would maintain the integrity of being able to overfly that airspace?
I mean, there's one question about how to justify a particular reaction on the basis of the law, and there is another one that has to do with what is the strategy behind the construction of the relevant sanctions or countermeasures that we take in any given case. I am no expert in designing sanctions regimes. It just seems to me that it would be far more effective to target the equivalent Michael O'Leary of Belavia rather than Belavia itself. That would make, I think that would be more painful in the circumstances rather than just to block Belavia itself. But again, as I said, this is a matter of appreciation, a matter of designing the particular sanctions regime in a way that will cause, that will put the most pressure on the state to comply and at the same time have the least amount of sort of perverse effects possible.
I'm grateful for your candour. Thank you very much indeed. Professor Jackson, are you in agreement there with your colleagues' view?
I know at the start the chair said that the human rights situation is being dealt with by foreign affairs, but we might see these things as connecting to each other. This is the kind of act of a regime under pressure, and there are systemic human rights violations ongoing. So binding the responses together may be strategically wise.
Okay, thank you. Thanks, Chair.
Thanks, Graham. Just a sort of closing question from me, and again, it goes back to sort of precedent, perhaps. I mean, the Civil Aviation Authority's action of suspending the Belarusian Airlines foreign carrier permit, is that the type of thing that would normally be invoked on safety grounds as opposed to sort of what we've seen here? I know this is relatively unprecedented, but can you think of examples where something similar has been invoked on a sort of non-safety basis to an airline?
Well, it depends on what you mean safety, because safety, especially in bilateral air service agreements, can have a rather broad...
Well, that's a great point. So by safety, I normally mean that there are concerns about the safe sort of engineering capability of an airline and their ability to maintain international safety standards rather than the sort of safety of the country from which they are domiciled. So, but it's interesting that you touch on the word that safety is a very generic term. So perhaps... do continue.
The reason I mention it is because, of course, when you read something like safety, then the first thing that you're thinking is airworthiness of aircraft. There have been situations actually where there has been suspension of Belarusian flights into Europe because of airworthiness concerns in the past. I think for a while Belavia was unable to land in European airports precisely because of its airworthiness issues, but I may be mistaken on that, so don't take me at my word. I would have to look it up. But the point is that there are also security exceptions in air service agreements. There are provisions that allow for the suspension of an air service agreement between states when there are security concerns that go beyond safety in terms of airworthiness, and in such a bilateral situation, then every state will assess for itself whether its security interests are being are on the line, and so will be able to suspend licenses and so on. So it would depend on the particular air service agreement in play.
Okay, Miles, do you have anything to add on that front?
Nothing to add, Chair.
Okay, well, the Minister has actually been listening in the room to large part of your evidence as well. In fact, when you actually said that would be a sort of political matter, that was when he walked straight through the door. But he's a lawyer as well, so when I appreciate the points he recognised. Absolutely fascinating to hear the evidence from you both in this space. I'll perhaps just sort of throw one absolute final one, Minister, if you don't mind. I mean, In this situation where we've seen the Russians now intervene and sort of make the point that if airlines are not flying over Belarus, they can't fly over Russia as an alternative, is there a real concern here that we could see the international standards unravel, or do you believe this is just a temporary matter which will be solved by diplomacy rather than legality?
History teaches us that it will not unravel. If anything, this type of escalation of countermeasures and countermeasures and sort of reactions upon reactions is common, and in fact, it's one of the cases that we use to teach escalation of countermeasures and countermeasures is an air service agreement from the 1970s between the U.S. and France, where the U.S. was doing something that France didn't like. France banned all the flights from the U.S. The U.S. then turned around and said, no, that's the first violation. It's not allowed. It's not a countermeasure. So we'll ban all the flights from France and so on. And sort of the situation escalated. It escalated enough so as to put enough pressure on the states to sort of sit down and resolve the issue or submit it to an arbitral tribunal, which is what they did in the instance. In this particular instance, we do have the ICAO Council, to which states parties to the Chicago Convention can resort to. We do have a possibility of appeal to the ICJ. We do have the possibility of using sort of countermeasures to push towards a negotiation of some sort. So I really don't think it will unravel. It doesn't unravel that easily. Rather, it will be an episode that will be resolved probably along these lines.
Excellent. Well, look, Antonius, Miles, thank you so much for lending us your academic legal expertise in this, and our best wishes to you and everyone else at Oxford as well. Thank you again.
Thanks all.